Much to ThinkUp's dismay, both Disruptive Products Inc. and Tastemakers filed separate motions to dismiss. Let's get into it. That's right, guys. Today we are back with a big update in the ThinkUp versus Disruptive Products lawsuit. If this is your first time here, we would really appreciate a subscribe. And for future updates and videos like these, click that alarm button for notifications. And lastly, if you like this video, please smash that like button. It really does help the channel. As I mentioned today, we are updating you on the ThinkUp versus Disruptive Products Inc. lawsuit in which ThinkUp alleged breach of contract for Disruptive Products. They're looking for damages on royalties owed. They're looking for penalty damages on top of that. And of course, we went into this in depth. You can check out that video on this channel where we go through the contract, we go through their agreement, the lawsuits, email communications, you name it. But we will touch a little bit on those today as we review these motions to dismiss. And if you watched that video, you probably know what's coming, as I definitely saw this coming, as did probably a lot of people. So let's jump into that first motion. Here we have a motion. Sorry about that. Filed in the Superior Court of New Jersey Law Division in Camden County. And this one is filed in support of the defendant Tastemakers LLC, and it's a motion to dismiss the complaint pursuant to R46-2A. As I mentioned before, the lawsuit by ThinkUp was against Disruptive Products and Tastemakers, and what's unique about these filings is both Disruptive Products Inc. and Tastemakers filed separate motions to dismiss as though they are two separate entities. Jump down here as we get into the complaint itself. And of course, we're just going to breeze over some of this so I don't bore you with all the legalese and get to some of the heart of the matter. And it says, through this action, ThinkUp Inc. seeks to recover monies it is allegedly owed for certain game development services provided to defendant Disruptive Products Inc. together with Tastemakers as the defendants and Tastemakers. ThinkUp Inc. asserts the same three claims against both defendants, including breach of contract based on the 2019 written agreement annexed to the complaint as Exhibit B. Under the plain language of the 2019 agreement, any proceeding to enforce the 2019 agreement shall be brought exclusively in New York County, State of New York. Based on the parties' agreement, ThinkUp Inc. is required to bring this action in the New York County, and as a result, this course lacks subject matter jurisdiction over this dispute. Now, I told you this was going to happen, that in that 2019 agreement, both parties agreed that jurisdiction over any dispute on the matters of that contract has to be filed in the state of New York, and ThinkUp filed their lawsuit in New Jersey. So what's the first action Disruptive Products Inc. and Tastemakers take? They want to move to dismiss for jurisdictional concerns. As we jump down here, this is kind of a repeat. It says ThinkUp Inc. asserts the same three largely duplicative claims against both defendants. One, an accounting of revenues defendants received relating to certain games ThinkUp Inc. alleges it helped develop, which is interesting. Breach of contract for certain revenues defendants allegedly owe ThinkUp Inc. related to such games. And three, quasi-contract and unjust enrichment regarding certain revenues allegedly owed by defendants concerning such games. TUI alleges that it was the developer of two lines of games for defendant, Arcade 1-Up and the Infinity Game Board Infinity Game Table. Although ThinkUp Inc. alleges certain oral agreements with defendants regarding both games, the complaint clearly alleges that after both lines of games were conceived and introduced to defendants by ThinkUp Inc. So ThinkUp Inc. went to them and said, here's some products we developed. And after any alleged oral agreement had been purportedly entered, so again, Jerry Cummings at ThinkUp Inc. said he and Scott Baccarat had an oral agreement, a gentleman's handshake agreement, that they would be paid 3% royalties for the life of the product on all products developed by ThinkUp Inc. for Tastemakers. So here they're saying after that oral agreement, after they created the products, TUI and DPI then executed a written agreement dated as of July 16th, 2019, namely the 2019 agreement referred to throughout the complaint and this response. While TUI claims that no representative of defendants ever explained to TUI or ThinkUp Inc. the differences or relationship between defendants, so the differences between Disruptive Products Inc. and Tastemakers, ThinkUp Inc. alleges facts in the complaint that show defendant were affiliated and related entities, and that ThinkUp Inc.'s knowledge of the same. So basically, it's saying the way that this is written is ThinkUp Inc. basically says we did know they were related, that there's some sort of affiliation between these companies. In that lawsuit, they pointed out that Dora DeVere was listed as working for Tastemakers and Disruptive Products. Likewise, other employees were in both of those companies. And he says, for example, ThinkUp Inc. alleges, among other things, that both DPI and Tastemakers were directed and led by the same person, Scott Baccarat. So again, here's a connection that they said they weren't sure, but they know that Scott runs both companies, with whom ThinkUp has worked, negotiated, and communicated with. ThinkUp Inc. entered into the 29 agreement concerning the games with DPI as the signatory. So again, they're saying, how can you claim you don't know who DPI is when you signed the contract with DPI and knowing you were working with Tastemakers? So surely you would have had to have known there's a relationship with DPI and with Tastemakers. ThinkUp primarily communicated with and received revenue payments from Tastemakers under the 2019 agreement. So again, you're cashing the check from Tastemakers that's paying you out based on the contract you signed with Disruptive Products Inc. So clearly, you know that there's a relationship with these two companies, and this isn't just out of the blue. So that one drives a huge wedge into some of the issues that ThinkUp is alleging regarding the 3% royalties for life claim. As we skim through this is a lot of background on what ThinkUp was responsible for their end of the agreement versus DPI or Tastemakers. And then we get down here, consistent with Section 1A of the 2019 agreement, which provides that ThinkUp Inc. will work with Disruptive Product Inc.'s affiliates to provide product development and related services for various brands and products. ThinkUp Inc. admits that it worked with Tastemakers in connection with the development of the subject games. So again, admitting they know that there's a relationship there. Notably, Mr. Baccarat, with whom ThinkUp Inc. admits it negotiated in business arrangements, signed for DPI. So again, the actual person who signed the agreement of the 2019 agreement was Scott Baccarat himself. Thus, complaint alleges facts for which it can be reasonably inferred that DPI and Tastemakers are related and affiliate companies. In fact, ThinkUp Inc. implicitly concedes as much by expressly asserting liability against both defendants under the 2019 agreement. So this goes back to their lawsuit ThinkUp filed specifically targeting and naming defendants, Disruptive Products Inc. and Tastemakers as two separate but connected companies. And so, this is the section of the 2019 agreement I told you about that was going to be a problem for them. It says the agreement in all matters or issues collateral thereto shall be governed by the laws of the state of New York without reference to conflicts of law principles. Developer ThinkUp Inc. and Company Disruptive Products Inc. consent to the exclusive personal jurisdiction of the courts of the state of New York located in the New York County and the federal courts located in such state and county, and any proceedings to enforce this agreement and agree not to interpose any objection or defense based on lack of personal jurisdiction or improper venue in any such proceedings. So, under this provision, ThinkUp Inc. waived any right to object to the venue of any proceeding in New York County. So, again, ThinkUp Inc. is required under this agreement to file their dispute in New York County. And Section 13 of the agreement, entitled Complete Agreement, contains the following merger and integration clause. So, this is where they get into, hey, the agreement's with Disruptive Products Inc., but it also covers all of our affiliates and other companies. It says this agreement contains the entire understanding of the parties hereto relating to the subject matter herein and can be changed only by a writing signed by all parties. So, again, no more verbal stuff. The agreement supersedes and cancels all previous agreements, if any, relating to developers ThinkUp Inc. retention by and or the furnishing of developer services to company or any of its affiliates or subsidiaries. So this is, again, a direct attack in the agreement on two of ThinkUp's claims. First, they're alleging they had that oral agreement that gave them 3% of products for life, because the 2019 agreement doesn't say that. It just says they get 3% of royalties sold up to while the agreement is in place. And so here they have in writing in that agreement, which ThinkUp signed without an attorney, mind you, saying that, hey, this agreement supersedes any other agreement we've ever had, written or otherwise. So anything that was verbally told to you is gone. This agreement covers it all. And the only way to modify this agreement is in writing. So one of the ThinkUp follows up saying, hey, we also were negotiating on royalties and paybacks for the Infinity game table that had a slightly different structure. Not only were they to get 3% of fees, but they were supposed to get 70% of development costs of any custom games they created for the Infinity game table, which they allege they never received. Well, do they have it in writing? This contract clearly states you can have no other agreement unless it's been done in writing, which they do not have. And lastly, of course, is the allegations of we don't understand who Disruptive Products Inc. is compared to Tastemakers. And that line here, the company or any of its affiliates or subsidiaries, think Tastemakers is a subsidiary of Disruptive Products Inc. So, thus, by the plain terms of the 2019 agreement, any prior agreement between ThinkUp Inc. and DPI and or between ThinkUp Inc. and Tastemakers as DPI's affiliates, whether verbal or in writing, regarding ThinkUp Inc.'s furnishing services for DPI and or Tastemakers as DPI's affiliates was superseded and canceled by the 2019 agreement. So, even though they don't need to, they are basically attacking his argument immediately. Then we get into they're citing specific cases as examples. This is why they've made some of these claims. These cases provide precedents for why this should be dismissed. You have a New York case here that covers it. We follow it up with a case out of the state of New Jersey that does the same. And essentially, we get into um, additional reasons, right? So ThinkUp Inc.'s alleged oral agreements regarding the games that were supposedly entered prior to the 2019 agreement do not permit ThinkUp Inc. to evade the forum selection clause. The integration provision in the 2019 agreement precludes any such argument, as it clearly provides the 2019 agreement contains the entire understanding of the parties relating to the subject matter. So again, that is a quote from the precedents in the case in New Jersey, and supersedes and cancels all previous agreements, blah, blah, blah. So we kind of covered that. So here they're picking apart based on the findings in these cases exactly why, right? And so you see this Delaretto versus Tatora, Primex International Corp versus Walmart Stores Inc. They're going through all of these cases. And then they have cases here like Groenveld v. Verb Tech Co. that give tastemakers the right to enforce the clause. And again, they're reiterating some of their conclusions here, regardless of ThinkUp Inc.'s conclusory legal allegations that the 2019 agreement is somehow ambiguous and parole evidence should be admissible, which contention is contrary to governing law concerning contracts with integration provisions such as this. It is clear that ThinkUp Inc. seeks to rely on certain provisions of the 2019 agreement it views as favorable to support its purported claims for breach of contract against Tastemakers. So, this is another interesting argument that Tastemakers' legal team is making. They're saying, on one hand, ThinkUp, you're arguing that this agreement is not whole and complete, that you had this verbal agreement for royalties for life. You're claiming you had this negotiated agreement for the software and royalty on the Infinity game table and Infinity game board, and therefore the agreement's not valid. But at the same time, you're suing me under the agreement. So, on one hand, you want portions of the agreement to count for your financial benefit, and you want other proportions not to count for your financial benefit. You can't have it both ways, right? You either agree that you have this agreement and therefore it's fully enforceable, or you say the whole agreement is invalid because of prior or other agreements. They know they can't. Tastemaker, you got to think that ThinkUp's attorneys know they can't make this claim, which is why they're trying to split the baby and hope the judge goes for it. But obviously, Tastemakers' legal team caught that and started pushing back. So, thus, the complaint clearly alleges a substantial nexus between the promises allegedly contained in the 2019 agreement and the claims against Tastemakers. And then it goes more into claims, and it says, since DPI is the only signatory to the 2019 agreement, but ThinkUp Inc. alleges Tastemakers was somehow bound thereunder and therefore breached its obligations therein, it cannot be disputed that the claims asserted against Tastemakers are directly derivative of both the obligations DPI assumed under 2019 agreement and the resultant claims for alleged breach of that agreement against DPI. So again, ThinkUp listed Tastemakers as a separate defendant, and Tastemakers is saying here, hey, there can only be one defendant. We're an affiliate of Disruptive Products Inc., so we shouldn't even be party to this to begin with. And you agree of that because that's why you're suing for those the damages under this agreement. So he's reiterating that same claim from earlier. So the 2019 agreement specifically states that ThinkUp Inc. and his team will work with the company and its affiliates, consultants, employees, and other team members to help bring products to life. Consistent with this provision, the complaint alleges that DPI affiliates Tastemakers played the main roles compared to DPI in the development, manufacture, and distribution of the games, was the primary representative with which ThinkUp communicated, and was the entity with which ThinkUp dealt exclusively and wrote checks and wired monies to ThinkUp for revenues from the games. Significantly, the 2019 agreement further provides that it supersedes and cancels all previous agreements, if any, relating to ThinkUp's retention by and or furnishings of ThinkUp Inc. services to the company or any of its affiliates and subsidiaries. So again, they're just going to keep hammering the arguments that ThinkUp is making throughout this motion to further give them bona fides as why it should be tossed for venue issues. Thus, by the express terms of the integration clause, the 2019 agreement was to encompass all agreements relating to ThinkUp Inc.'s game development services for DPI and its affiliates, including Tastemakers. So what they have to do here is tie all that back in to remind the judge, hey, we had no other agreement. So they can't sue under other agreements because of this written contract. So they can't weasel out of the venue clause because this contract covered everything between DPI and Tastemakers for all products and all services, including any other affiliates a DPI may have. And so you can't sever this claim and that claim to keep some of the case in court. They're all one thing. And if you agree that it should be dismissed on venue issues for one part of the action, then it all has to be tossed as part of the action. That's the goal here of these provisions. And given the complaint's numerous references to the 29 agreement and its attachment thereto, and ThinkUp Inc.'s allegations that defendants failed to pay revenue allegedly promised on, it is clear that ThinkUp is seeking to enforce rights it purports to have under the agreement against both defendants, since all disputes relating to ThinkUp Inc. services purported rights under 2019, which merges with or supersedes any prior agreement with Tastemakers, or to be exclusively litigated in New York, including those with Tastemakers, DPI's affiliates. In sum, given the substantial nexus between the 2019 agreements and the claims against Tastemakers, the largely derivative and overlapping claims asserted against Tastemakers and DPI in the contractual terms evidencing Tastemakers' third party beneficiary status, Tastemakers should be permitted to invoke the forum selection clause, and the dismissal of the complaint for lack of subject jurisdiction is warranted. And this goes into again why Tastemakers has the right to assert the clause, even though the contract is between ThinkUp and Disruptive Products Inc. And so, in conclusion, whether viewed under New Jersey law or New York law, this court lacks subject matter jurisdiction to entertain the present action due to the exclusive forum selection clause designating exclusive venue for this dispute in New York County. Dismissal of the instant action is therefore warranted to adhere to the legitimate expectations of the parties manifested in their negotiated agreement. Obviously, if ThinkUp Inc. wishes to pursue its claims alleged in the complaint, all of which lack any merit, which of course they have to say that, it is free to try to do so in New York County, where it agreed such claims may be exclusively brought. Therefore, the court should dismiss the complaint in its entirety and grant such other further relief as the court deems just and proper. So, again, in summary, Tastemakers attorneys are saying here there was an agreement between ThinkUp and DPI. That agreement covered all other agreements, made them all moot. It also covers, and we're included in that agreement because we're an affiliate of that agreement states that they can only file action in New York. So dismiss this because New Jersey has no jurisdiction. So that's the end of their motion. And filed on the same day in the Superior Court of New Jersey, Disruptive Products submits their motion to dismiss the complaint with prejudice pursuant to Rule 462A. So they go one step further and say, we want to make sure they can't refile. And so, again, different legal team representing Disruptive Products Inc. versus Tastemakers. So there's some separation there. And you're going to see the same arguments here, basically. The defendant, Disruptive Products Inc., submits this memorandum of law in support of its motion to dismiss the complaint of plaintiff ThinkUp Inc. pursuant to Rule 46-2A for lack of subject matter jurisdiction due to an exclusive forum selection clause contained in the parties' agreement dated July 16, 2019, mandating that the dispute be heard in the state of New York, County of New York. And straight off, right away, ThinkUp Inc.'s complaint should never have been filed in New Jersey. And then it goes into much of the same stuff we've talked about before, and nothing about the forum selection clause. So previously they talked, there are a handful of reasons you can legitimately poke holes in a jurisdiction clause, and this is them saying none of those are the case. So nothing about the forum selection clause was unclear, subject to interpretation, meaning a normal person reads it, they know what it says, right? Subject to the jurisdiction of New York County in the state of New York. No fraud exists in connection with the forum clause, so they weren't trying to pull anything over on them. It was all clearly stated. There was no scam. You know, this company is located in New York, headquartered in New York. And so no fraud there, and nothing concerning the form selection clause is unreasonable, unjust, or contravention of public policy in litigating this dispute in New York County, which would not be inconvenient to ThinkUp. So what they're saying there is, it's not like ThinkUp is over in California and you have to fly to New York to come fight this case. So you can't argue inconvenience. You're in New Jersey. It's like a half-hour drive to come up here and go to court. So you can't tell us it's inconvenient and therefore you need to file in your home state. So again, giving another reason why this should be dismissed for venue issues. The above and caption proceeding in force 2019 agreement, which triggers the application of the form selection clause. As a result, TUI was contractually required to commence this action either the state or federal courts of New York located in New York County. ThinkUp Inc. was not permitted to commence an action to enforce the 2019 agreement in New Jersey. And again, much of the same arguments. This is where they're saying they had all these, they entered the agreements, the agreements cover the stuff. A lot of this is repetitive because it's the same arguments both sets of attorneys are making. And again, the affiliates, employees, yada, yada, yada. There's the provisions of the agreements. They're citing the case law and they're citing some different cases. And here there is no allegation. Again, this is fraud or the difficulty foreign selection clause. Consent is to the exclusive personal jurisdiction of the state. ThinkUp Inc. has asserted a breach of contract claim against DPI based primarily on the 2019 agreement which ThinkUp Inc. annexed to its complaint and thereby incorporated by reference. By alleging DPI's breach of the 2019 agreement, ThinkUp Inc. concedes the enforceability of the 2019 agreement. So again, this agreement is still in effect for this enforceability because you're trying to claim damages based on that agreement, which the necessarily encompasses the forum selection cause. Given ThinkUp Inc.'s failure to adhere to the forum selection court, the court lacks the requisite jurisdiction to entertain the present action. Dismissal of the instant action is therefore warranted to adhere to the legitimate expectations of the party as manifested in their negotiated agreement. And says, for the above reasons, defendant Disruptive Products Inc. respectfully requests the court pursuant to the R46-2A dismiss the complaint of plaintiff ThinkUp Inc. with prejudice for lack of jurisdiction. So there you have it. That's our big updates. Both companies, Disruptive Products Inc. and Tastemakers, have filed their initial requests for dismissal based on jurisdiction issues. While I am not an attorney and only play one on TV, I cannot I can't see ThinkUp case surviving these motions. In all likelihood, the next update to this case is going to be a dismissal in New Jersey. It's pretty clear that there is a written agreement, and that agreement puts the jurisdiction in New York. So we'll see what happens when the judge rules and whether this case just ends there or we are off to more motions and getting a date set and any interrogatories, which should be interesting if we get that far. But again, I just do not think that will happen. This case is likely to get bumped very soon. So as soon as we find out, we will give you an update. And until next time, have fun.